Court, all rise, please. County Superior Court is now in session. Please be seated. Thank you.
Your Honor, for the record, this is an in-person event in a civil matter. This is docket number 2180 CJG-04.28.21. Carol Gray et al. Versus Susan Audette in her capacity as acting town clerk of the town of Amherst. This is before the court for a preliminary injunction requested by the plaintiffs in this matter. And if the parties could please identify themselves for the record and who they represent.
Good morning, Your Honor. Carol Gray on behalf of the plaintiffs.
Okay, good morning.
Your Honor, Lauren Goldberg from KP Law on behalf of the town of Amherst and the town clerk.
Okay, good morning.
Good morning, Your Honor. Greg Corbo, also of KP Law, representing the defendants, town of Amherst.
Okay, good morning. Now what I have before me is the plaintiff's request for a preliminary injunction. But before we begin, I know that there are a number of individual plaintiffs, and they certainly have a right to be here and participate. Because of COVID, we're limited in the courtroom. We have access through the phones for people. I just want to make sure that we're comfortable with that. Unfortunately, the clerk and I talked about moving it upstairs. We could have gotten a few more people, but the acoustics up there are troubling at times. But we want to make sure that people have access to this. It's at least of interest to the town of Amherst. And because there are separate plaintiffs, normally each plaintiff has a right to come in and discuss whatever they want to discuss, can be limited by the court in some way. Ms. Grant, and I know you're an attorney. I remember when you were in Hamden practicing a lot of criminal law. I take it that you're not in an official sense, but you're kind of representing the views of the other plaintiffs, or will they be requesting to speak?
Thank you, Your Honor. Actually, I have entered a notice of appearance.
Oh, you did?
So I was pro se originally, but I decided to become official.
Okay, very good. So you'll be speaking on behalf of all the plaintiffs.
Yes, and I do want to just say we have some plaintiffs here, but we very much appreciate that the court is protecting the safety, and some are listening in, so thank you for that option.
Okay, very good. Now, I spent some time reviewing this matter. It came in last week. We marked it up for a hearing. I received, it was about 9:30 or so, the memorandum from the defendants, and there's many exhibits there. I spent a fair amount of time reviewing that. I have to say, it wasn't in detail. I didn't check the cases or anything like that, but I do have a familiarity with this. And it seems to be, from what I have seen, and at least from my perspective in dealing with a preliminary injunction, that the parties agree as to many things. And first of all, they agreed that, I believe it was on April...
I'm sorry, Your Honor, we have a motion to continue that's pending that I filed last night. I just wanted to bring that to the court's attention.
I denied that motion in writing yesterday. You did not get a copy?
Sorry, Your Honor. Yes, I certainly did get a copy of that, but I filed another one last night after receiving 200 plus pages of documents because I simply could not read through them. So I'm here having not read 100 pages of the defendant's pleadings, having not been able to discuss any of them with the plaintiffs, having not been able to do research. I would have gotten affidavits from, I see that much of their pleadings are about the public interest of the library, and we have two of the plaintiffs are former presidents of the Jones Library Trustees. I would have gotten affidavits. I asked for a continuance of a week, or even a couple of days, so I could actually read through everything. And if a continuance is not granted, I ask that those be excluded because the choice was read 200 plus pages and get no sleep or be here before Your Honor. And that's just not a fair choice. That's really trial by ambush. Okay. And it's just not a fair playing field.
I was not aware of that motion. I have not seen that motion.
I have a copy for you.
No, I trust you that was filed. Well, that is in the nature of a preliminary injunction. The plaintiff has all the time to prepare. Then they request an emergency hearing, which we grant. And the defendants then are scrambling to get things done. So in a preliminary injunction, this is not uncommon. We see it. If you like some time, a few days afterwards, to make any comment with respect to any things they file, I'll certainly give you that opportunity. but I'm not going to continue the hearing. And we see this all the time because the plaintiff has an emergency motion, and we have to schedule it immediately. That puts the defendant, who may have no awareness even of the lawsuit, at a great disadvantage, so they end up scrambling. So given the fact that there was a motion filed, I'm going to deny the motion to continue this hearing, but I certainly, if there's any points afterwards the party wishes to respond in the next couple days, I will allow them to respond.
Thank you, Your Honor. We would like to keep the record open. And I would just point out that more than 100 pages of the affidavits were collected April 23rd and 24th. So they were just held by the defendant for days and then produced 2.5 hours after close of business last night.
I have a feeling that all may be moot, but that's one of the legal issues we'll deal with down the road. But let's see where we go on this
Thank you, Your
point.
Honor.
As I indicated, I think the facts are not in dispute. I don't have a lot of information as to how the funding was done or anything, and I know there was some in the defendant's thing, but I know that on April 5th, I guess the town council of the town of Amherst voted to authorize the borrowing or start going forward with the project, and that the plaintiffs sought to petition the town under Section 8.4 of the Charter, which allows a group of citizens or one citizen then to challenge what the town council has done. That's all undisputed. Now, what I understand the plaintiff's claim in the complaint is because of the COVID conditions, the collections of signatures were very difficult. And I have to say that we're seeing that throughout our economy, through our social networking, COVID has been devastating. And so, and I know there was a lot of affidavits, there were statements in the complaint. I certainly accept that that would be very difficult to do anything, including collecting signatures. But what the plaintiff has requested is that due to the COVID emergency, that they be allowed to use, and there's 3 things that I've identified, use electronic signatures. Second, extended the timeline to collect the signatures. And third, requesting a 50% reduction in the necessary amount of signatures. I think that was set in there. Now, as I understand it, the plaintiff is not contending that the council did anything wrong. They didn't violate the section there. And it's simply that because of COVID, that there's an emergency situation and they're at a great disadvantage and they need this relief. That's what I understand the complaint is about. Is that in fact correct?
Yes, as to certainly the 3 types of relief. We're looking at the Goldstein case and asking for the same. I would say that the town council did do something wrong by failing to give an accommodation when accommodations and revisions to the law are happening everywhere, even in the court.
But
Yes.
that's what I said.
Okay.
These are the 3 things that you specifically pointed out, those accommodations.
Correct.
I'm certainly aware you're alleging they failed to give the accommodation.
Correct. And another thing too, but not the subject of this. So we have, as you know, we've submitted, according to the clerk's office, 1,088 signatures, and more than 200 were disqualified. We would say those were wrongly disqualified.
Yeah, but that's not a part of this hearing. I'm not
Yes,
going to
Your
hear
Honor.
anything on that.
Absolutely,
You
Your Honor.
have a right to pursue that.
Certainly.
And whatever remedies. This is simply, you're saying that the town did not provide these accommodations.
Correct.
Okay. So I think that's my understanding of the facts. And I guess the major question is, I don't think the court has any jurisdiction to do anything with respect to this. We only deal with violations of law. If you had said they violated this section, then the court can step in. If you had said they violated a constitutional principle somehow,
They did.
but sit down,
Sorry.
the court will step in. Right? But there's nothing. What you're saying is you're entitled to an accommodation. Now, An accommodation can be given to you by the executive branch. It can be given to you by the legislature, but accommodation cannot be given to you by the judiciary. We don't do those things. That is for the governor to step in and say, because of COVID, we're changing things. That is for the legislature to do that. The court does not do that.
Your Honor, we think fundamental constitutional rights have been violated in numerous ways. The First Amendment right to petition your government, Article 9 and Article 19.
But you're not saying, you never said they did anything wrong. They filed
Yes, they did.
Followed what the law was.
No, Your Honor, the constitutional violations were in not allowing accommodations. That is absolutely a constitutional violation. In fact, that was the very holding of Goldstein and the holding of Grossman.
I guess you and I differ with this, unless I see a case right on point where they're required to make an accommodation. It's just like if a group of taxpayers came here and said, you know what, we think the town should suspend collecting real estate taxes because of the pandemic. And if they don't, they're not making a fair accommodation given our situation. There's no constitutional right to suspend that.
Your Honor, if I may quote from Goldstein, they say regarding electronic signatures, to be sure, wet signatures can still be obtained, but the ability to do so safely has been greatly diminished or been made significantly more laborious. No fair-minded person can dispute that the fundamental right to run for elected office has been unconstitutionally burdened or interfered with by the need to obtain the required wet signatures in the midst of this pandemic. The exact same principle applies here to petition. There has been significant interference. But why aren't you dealing with the governor? He's the one who has absolute authority to require them to change it. The Goldstein court believed it was the role of the judiciary, and we are following exactly what the Goldstein court said to do. We're using the very remedies that they said applied. The question should be, do the extraordinary conditions that existed during Goldstein still exist today? And we absolutely believe that they do. Right here in Massachusetts, there have been 684,000 confirmed cases of COVID, 17,592 deaths. In Hampshire County, 301 new COVID cases in the last 2 weeks. There have been 93 new confirmed cases in Amherst between April 4th and April 17th. 39 active cases.
Listen, I do understand the devastation
If Goldstein could rule,
wrought.
this court can rule. It's the exact same principles. Fundamental constitutional right under the First Amendment to petition your government. Fundamental constitutional right triggering strict scrutiny under the Massachusetts Declaration of Rights. Article 9 for voting rights. Article 19 for petition rights. This is absolutely the jurisdiction of the court, which is exactly why Goldstein ruled. And we're asking for the court to do what the Supreme Judicial Court of Massachusetts has said is required in extraordinary circumstances. Goldstein is exactly on point. For the court to turn a blind eye to enforcement of fundamental constitutional rights would be fundamentally unfair.
Well, I mean, the problem we get into is that argument can be made with virtually any time frame, any action taken. That really is for the SJC if they're going to resolve that issue. But let me just turn, now that I understand what the argument is, let me turn to the defendants to hear what they say on this issue.
Thank you, Your Honor. It's our position that Goldstein provides a part of the framework for analyzing this case, as does Grossman, the case also cited. However, we do believe that the case is moot. The plaintiff said that they had a substantial interference with their right to collect signatures. The language in the charter is completely neutral as to collection. And they proved that they could collect signatures because they collected more than the minimum required by the charter. Even if this court were to go on to consider whether constitutional rights are at play, it is a well-known tenet of law that the filing of petitions, the deadline for filing of petitions cannot be altered. It is mandatory with respect to a private individual. So, for example, if a candidate wants to get on the ballot and doesn't file sufficient signatures during the time frame that's allowed, There's no way that the town clerk can bend the rules and allow that to happen. It's the same situation here. State law sets forth the process for regulating the validity of signatures, but the process for collecting signatures is not burdened at all by anything expressed in the law. Certainly, we are sensitive to and understand that COVID has changed a significant amount of normalcy and that this is a different kind of normal. Just recently, the governor has increased the gathering limits. He has removed the mask mandate starting April 30th. He has allowed additional people to gather inside and outside, and over 2 million Massachusetts adults have been vaccinated. The world today is night and day from the decision in Goldstein. Even in Grossman, which followed a mere 4 months later, and Goldstein was decided in April of 2020. It was filed in March of 2020. And in Grossman, just 4 months later, the court found that there was no significant interference with the right to cast a ballot, which is much more directly a constitutional right that was being affected directly. And they concluded that the late mail was not a substantial interference. Instead, they found that it was enhanced to allow the participation of additional voters. It was specifically understood that they had other avenues of relief. They could vote early. They could bring their ballot to the polls. And so the court decided Grossman would not be entitled to have her name printed on the ballot. In Goldstein, and I appreciate that there are portions of Goldstein that paint a very dramatic picture. I think that there was a very traumatic issue back then, and it remains in concept today, but there is no similarity between a mandated lockdown, closing of schools, closing of businesses, closing of public buildings, a stay-at-home advisory from DPH saying you may only leave your home to go to the grocery store or to go to the post office. There are none of those restrictions right now. And any choice that the plaintiffs make not to go out into the world is their choice. Certainly, we can respect that. But they weren't the only ones that could gather signatures. This is a process that's open to all the registered voters in Amherst if they would like to veto a decision made by their elected town council.
Why would you say it's moot, though? I mean, with the claims that they raise, they could have done a better job of collecting signatures. It doesn't appear to be moot at this point.
We would argue, I'm sorry.
Go ahead.
We would argue, Your Honor, that it is in fact moot. The plaintiff alleges that they could not gather sufficient signatures of registered voters because of COVID-19. They needed to get 862 certified voters to sign. The plaintiff filed 1,088 petitions. So that undermines the claim that they couldn't gather enough signatures. They did gather enough signatures. It just turned out that not everyone who signed was in fact entitled to have their name be certified. And that process, Your Honor, is not any different during COVID times than any other time. In fact, the Secretary of State has been authorized by Chapter 53, Section 7, to come up with a whole list of reasons to certify or not certify. Those apply to the certification of any papers at any time. And it is not unusual for a portion of signatures that are submitted not to be certified as those registered voters.
Right.
The plaintiff, several of the plaintiff's affidavits show that they understand that there is a best practice, which is to collect more signatures than necessary because of that risk. They did collect more signatures than necessary, and after certification, it's below the amount required by law. And if you look at the charter, Your Honor, which is adopted by the town in the spring of 2017, I believe, the Charter Commission that proposed this new charter, which changed the form of Amherst government entirely, met over 65 times. They held listening hours. They held public input, public feedback. There was a significant focus on whether the existing voter petition process in their current charter should be incorporated into the next charter. And what they did is they expanded the ways that the public can access the town council and the Board of Library Trustees and the school committee. They said if 200 residents, just residents, provide their names and addresses and ask for an open meeting, the council is mandated to hold that meeting. If one resident provides a proposed petition, they have the right to do with it what they want. They could move forward and to consider it formally. If 250 registered voters sign that petition, then they must hold a hearing and there's notice provisions required. 8.3 and 8.4 are about the initiative process and the referendum process, neither of which is mandated by law, but which was constructed intentionally to allow the goals of the town to be reached while recognizing that the people need to have a say. With the initiative petition, there's a two-stage process. They have to collect 250 signatures originally. If the council doesn't agree, they have to collect 250 more.
And I don't think there's any dispute from the plaintiffs that it's an appropriate procedure and they spent time. I think what they're saying is, given this situation as it exists now, and yes, there's a difference from last year to this time, but given as it situates now, we were entitled as a matter of constitutional law to these accommodations. And included within the accommodations was to reduce the number to 50%. So I take it it's not moot. It's simply your argument is we're not in the same situation now as we were before, and therefore the accommodations are not appropriate.
We would go further than that, Your Honor.
Okay.
We would say that the question of whether the number of signatures was filed is a jurisdictional issue. In Goldstein, the secretary conceded that the situation that arose between the time they gave out nomination papers and the time that they needed to file was very different. And because of that, he agreed to, he worked with the court, in fact, to lower the number of signatures that needed to be filed. The Goldstein court chose not to act on a number of other things, including extending it, and they extended one deadline. But they did not allow electronic signatures, even though that was requested. And ultimately, what that court did is it skipped part one of the two-part process that we need to make a decision here today. And because the secretary conceded, they didn't look to see whether there was a substantial burden on the rights of the plaintiffs. That was agreed to. They went straight to, how do we fashion a remedy? How do we fix this substantial burden? And they came up with a narrowly tailored way to do that, that the secretary, the chief election official of the state, approved. That is very different than the situation that we have here today, and it's very different than the situation in Grossman. The first requirement is to ask whether there's a substantial interference. How do we decide? It's decided on a sliding scale, looking at the harm to the plaintiff if it's granted and the harm to the public if it's not. And the court says with some direct access to ballot issues, which was the Goldstein case, that we have to employ a strict scrutiny level of review. However, in Grossman, they do not employ a strict scrutiny level of review because they do not find that there's a substantial burden on the plaintiffs because the deadline for filing absentee ballots could not be extended. And we would submit, Your Honor, that on any scale, that this case is a continuation on a line, a continuum of the Grossman case. The plaintiffs here have not shown that COVID is the reason that these signature requirements, timelines, or number of signatures are a problem, are substantially burdensome. The plaintiff hasn't shown anything about that. And while there are some affidavits, most of it is referencing things that other people said and did. We don't have any explanation of why the plaintiff didn't ask other people to help. We don't have any explanation of why they didn't divide the signature gathering by person. If each of the plaintiffs had gathered 5 signatures a day, they would have hit the minimum number. If they gathered 10, they would have filed double that. That's not an undue burden. The referendum process, and why I was talking about the initiative a moment ago, is a very serious process with very significant results. The charter specifically gives the people the right to overturn a vote of the town council if within that time period they file the right number of signatures. Because that framework, it's been in place for 2 years. There's no doubt, especially based on the affidavits filed by the plaintiffs, that they knew that those were the rules. They picked up their petitions on the 6th and the 7th. It took them until the 7th day to ask about electronic signatures. To date, none have been filed, so none could have been rejected. And the number of signatures that they would need to get was also set by statute, by the charter. So this was not a surprise. The project wasn't a surprise. It was out in the public for at least 10 years. If you look through the affidavits, you'll see the council's held at least 20 meetings, the town council, where this has either been on the agenda or been the sole topic of discussion. And so there was no surprise element. It didn't all of a sudden become too burdensome.
So what you're saying is it simply wasn't the type of emergency that warrants this relief?
Yes, sir.
That there's not a jurisdictional issue I should be aware of? Is that, I'm having trouble understanding what a jurisdictional issue would be here.
In my view, the evidence that the plaintiff has submitted with respect, and that we have submitted with respect to the number of signatures filed, demonstrates in and of itself that there was not a substantial burden on the plaintiffs caused by COVID.
And so they're not entitled, just looking at the merits of this.
That's right.
Okay.
So I don't even get to the sliding scale and whether there's a rational basis or strict scrutiny, because they haven't presented evidence of any type of substantial interference. No doubt collecting signatures is hard. I'm sure it's supposed to be. You know, the referendum process wasn't supposed to be easy. It was supposed to be hard enough but not impossible. Okay. And that is what the plaintiffs did. They had 1,088 signatures filed. They needed 864, and they filed 842. So they, by their own admission, acknowledged that it was possible to collect the number of signatures needed.
Okay. I think I said, let me go back to Attorney Gray.
Thank you, Your Honor.
Given what we've heard, what are your thoughts?
Thank you, Your Honor. Several thoughts. First, as we know from Goldstein, it's not the 864 that you really have to turn in to have a petition succeed. Goldstein says that really you need to have 2/5 more to be on safe ground. We did not have 2/5 more. 2/5 more would be 1,210 signatures. We, according to the clerk's office, turned in 1,088 signatures. That means we would have needed 122 more signatures to qualify for the 2/5. And we, as according to the clerk's office, we're short 22 signatures. So had we turned in another 122, it seems certain that the petition would have been certified and succeeded. In terms of the idea that things are now different, well, one of the places you would go to get signatures would be town meetings, meetings of town committees where people are registered to vote. All of those are online. Town hall is completely closed. You cannot even walk in. They come to the door and meet you. The town council meetings are all online. There are no, you might go to a political gathering. If there's a political rally of some sort, you might get dozens of signatures there. Goldstein actually refers to that. There are no large political gatherings. There are, in terms of the affidavits, Ms. Jamate said that when she was doing political organizing in the past, she talked to people after school while waiting to pick up children. The schools were saying no one is allowed to gather after school. UMass Amherst has the Mullen Center, which is a huge forum. It's completely closed, no events. In fact, it was turned into a testing center for COVID. Considering that everything is virtual in terms of meetings where you might go to collect signatures, this is a huge impact. In terms of the timing of when we file things, the group tried in earnest to collect signatures under the current law and discovered after several days that it was a Herculean task. That when we go to the door, some people won't open the door, they'll open it very, very little. Some people won't touch the pen. One of the affidavits discusses a 93-year-old woman who was willing to sign, and then when handed the pen and the petition, she says, I can't touch anything, I'm 93, I can't touch anything. And some people, as you saw from the exhibits, here is one sign that was on the door that one canvasser encountered. It says, we are self-quarantined. Please leave mail in box below. Any mail we are sending out will be in the box. The defendant says, we should have asked for help. Well, some people are not vaccinated. So one of the affidavits discusses how one of the people who was very eager to be a canvasser said he simply could not do that because he had a child at home. Scott, I draw your attention to Scott Brackenridge's affidavit, and he said because of his family situation with vulnerable people at home, he could not canvass. Other people had only been partially vaccinated. There was also, this happened to coincide with when many people became eligible for the vaccine on April 5th in Massachusetts. So numerous canvassers had to take a day out to go and actually get a vaccine, some driving a couple of hours to do that. And then there were the side effects of the vaccine in terms of where you canvass. So this picture I was attached to the pleadings is of one hallway. It's 3 feet wide with doors on either side. It's impossible to canvass safely in this setting, and yet this is exactly the kind of apartments where you could get many signatures quickly in the past. And yet, after one try here, when people came to the door without masks, it was deemed unsafe. And so all of the apartments in this complex could not be canvassed because it was just not safe. It's not worth getting COVID and dying, even though this cause is of great importance to the public. I'd also point out that I'm glad that counsel referred to the case of Grossman because I think it's important to discuss that. That case actually revolved around the governing body realizing that there needed to be new rules because of COVID. That case was based on the legislator passing, quote, an act relative to voting options in response to COVID-19. So that legislature, unlike the town council of Amherst, realized that we cannot use the same rules because it would violate fundamental constitutional rights. And so that legislature created alternatives because of COVID. They decreased barriers to registering to vote, increased in-person voting options, calls for new safety protocols for in-person voting, expanded the availability of absentee ballots, and implemented a statewide plan for voting by mail. And I'd also draw your attention to, and that's on page 4 of the case, if you also go to the preamble of that law, they say that the purpose of that law is to, quote, forthwith provide for increased voting options in response to COVID-19. Therefore, it is hereby declared to be an emergency law necessary for the immediate preservation for the public health and convenience. So they recognized that this is an emergency. The reason they declined to give relief in that case is they said there's no fundamental right to mail-in ballots. That is not what's at issue here. What's at issue here is a fundamental right to petition your government. A mail-in ballot doesn't require going to the door of a hallway that's 3 feet wide and risking your life. This is a very different case, and I think that that case actually supports us. The Goldstein case made it clear that when it comes to voting, and this issue is not just about petitioning, it's also about voting, because this referendum would be created so people could vote on whether they want tens of millions of their tax dollars to go for a project. In terms of the public interest, putting this on the ballot is the greatest thing you could do to find out what the public interest really is. Let the public weigh in. In terms of what scrutiny applies, Goldstein said that when it comes to voting, and actually Grossman also said, we do consider this to be a fundamental right. Strict scrutiny should apply. And the question is, does COVID significantly interfere with petitioning efforts? I think it's unquestionable that it does. Considering there were 22 signatures short, to say that somehow, despite all of these shutdowns, 22 votes would not have been gained had this not been COVID, it's just not looking at the situation in a way that recognizes the dangers. Obviously, I also want to point out the petitioners did do everything possible to try to get this resolved at the earliest possible time. So we made best efforts to petition and realized in a few days that COVID is making this extremely difficult. And so we, within 1 week, we emailed the town clerk and said, could we have electronic signatures? Now, defendant says, how could we can't claim that there's any injustice because we didn't turn in any. We didn't turn them in because the town clerk said they're not allowed. So they're really saying, why didn't you violate the law when you were told by the town clerk they were not allowed? And then on April 15th, we sent a letter to the town manager, the president of the town council, and the town clerk, again saying, please reconsider. We should be allowed to have electronic signatures. And then we received no reply that day. On April 16th, I followed up and said, could you please confirm receipt of our letter? And then I received a letter from the president of the town council saying that they would not call a meeting, they did not consider this to be an emergency, and that they denied all forms of relief. Every single form of relief, and they wouldn't even get the body together to talk about it. I filed a reconsideration and said, well, even if you don't consider an emergency, although we see from the legislature in Grossman they absolutely consider an emergency. We see from every Massachusetts website about COVID that this is indeed an emergency. Nothing has killed so many people in Massachusetts in our lifetime other than this. Clearly it's an emergency. But the reconsideration said, even if you don't call an emergency meeting, call a meeting complying with the open meeting law. This was on Friday, and our petitions were due the next Tuesday. They could have on Sunday Friday posted a meeting under the open meeting law, called the meeting on Sunday, and given 1 week relief. In terms of prejudice, and one of the things that the court looks to is, were there reasonable alternatives? It would not have harmed the defendant to give 1 week addition for canvassing. Here we are more than 1 week after the date, and there's been no prejudice to the defendant. So they could have easily done that, but they refused to even call a meeting compliant with the open meeting law. If they'd called it on Sunday, they could have given us additional time. Even if they'd given us 2 additional days, we would have met that bar. They gave us nothing. Even though we are in a state of emergency nationwide, even though the Goldstein court and other courts that have looked at this have said absolutely there should be accommodations because of COVID-19, and they gave none. And that's why we're here. And it's absolutely appropriate to give an accommodation when we are in the middle of a pandemic.
And as I understand it, the accommodation that you're pushing is simply additional time to secure the signature.
Absolutely, Your Honor. Well, we asked for 3 accommodations, but that accommodation would certainly be sufficient. If 1 week would not prejudice the defendant, it's a reasonable accommodation. It's completely in line with what Goldstein said, and we ask the court to grant that.
Okay, thank you. Let me give a final word to the town.
Yes, thank you, Your Honor. I appreciate the opportunity to follow up. The first thing that I want to point out is that the legislature has the right to change dates relative to elections. Both Goldstein and Grossman make that point. They're about changes in the law. The law that is referred to in Grossman is the law that allowed people to vote, all people in Massachusetts to vote by mail. Under the Constitution, there's 3 purposes for which someone could vote. That law was the law that's being referred to. Grossman alleged that the post office delays were going to impact the ability of people to return their ballots. And the court looked at, were there other alternatives to return the ballots? And there were. And that situation is here as well. First of all, if the plaintiffs were granted the relief that they're seeking, they would effectively have accomplished their goal, which is to prevent the town from moving forward on an important project supported by the Board of Library Trustees and the town council.
Okay, run that by me again, because I didn't understand that. If they were given, let's say they were given a week to extend the time.
Yes.
How does that accomplish their goal? Let's say they did that and they didn't have enough signatures. I think it... Go ahead. Explain how that...
Certainly, Your Honor. The grant, the project itself is a $36 million project. Right. And it's subject to a grant from the Massachusetts Board of Library Commissioners of $13.6 million. That $13 million grant is it's part of an annual grant program. At the end of the fiscal year, all monies that haven't been spent close out to the Massachusetts State General Fund like all other annual appropriations. The grant that's provided is provided in segments, and for the Mass Board of Library Commissioners has said they need to know by Friday. We need to sign by Friday, April 30th. And that if we don't, number one, we're not guaranteed the grant. They indicate that they'd like to put us back on the list, but that's never going to be a guarantee, particularly with the way that the state budget is. In addition, the town has done a significant amount of work to get to this point. They've been on the wait list for that grant 2 other times. They went through the process of preparing the public to know about this. They started talking about this 10 years ago, at least since the council was elected in December of 2019. 20 meetings have been devoted to it. There is no question that anyone who wanted to be ready to stop an important project supported by the chief elected official of the town and the Board of Library Commissioners with respect to their own building should have been prepared. Their lack of sufficient signatures is of their own doing. They should have known that the council put out very early on that its last day to vote on this project was April 5th, and they did vote on April 5th. So before that, anyone who wanted to challenge it should have known that they needed to collect 5% of the signatures of the registered voters in the town in order to do what they wanted to do, which is to make the council reconsider its decision, its 10-2 to 1 decision. Assuming that that wouldn't happen just based on those numbers, Your Honor, the next phase would be for the council to put that on a ballot at an election. And that requires a delay of 35 days under state law. We can't waive it. We can't advance it. There's nothing that we could do about that. So any delay has kind of a cascading effect on the town's eligibility for the grant, its ability to sign these papers, and finally on the cost of the project. We're not talking about a private entity that's looking to expand. We're talking about spending public money that's raised through taxation, public money that's donated to the town. It is public money that will pay for this. The analysis that we've done is that as soon as we fail to sign tomorrow, then we jeopardize the chance to get the loan at all, and it's definitely delayed. And if we go past June 30th, it'll be gone in its entirety. The MBLC has told us that grant, that if we don't sign that grant by Friday, that the risk is that they won't be able to get the comptroller's office to issue the check to the town within the time frame of this fiscal year.
What would prevent you from signing this by Friday? How does this court interfere with that? Because this is not the final decision. It clearly is going to be going up and take a great deal of time.
Your Honor, the town felt uncomfortable signing that document without coming here first. The town has tried to be fair and transparent about all of the goings on with respect to the library project and with respect to the timing for decision making. We believe that the plaintiffs have filed now and asked for 2 delays already because they know that waiting past Friday creates a problem. It is correct that if a preliminary injunction doesn't issue, there is nothing that prevents the project from going forward. If the preliminary injunction does issue, either an additional amount of time, a reduction in signatures, or electronic signatures, we can't move forward because we'll have missed our April 30th deadline. And even if we do, we're moving forward at a great expense to the town.
So what you're saying is the court has to decide this by Friday.
Yes, please, Your Honor.
Okay. At least from your perspective. Okay. Anything else?
Yes, thank you.
Go ahead.
I'll try to be quick. The other thing is if the petitioners had come to this court on April 6th and said, we can't collect enough signatures, COVID is going to impede us, the only signature gatherers we have are unvaccinated or thinking about vaccination, it would have been the time to do so. The plaintiffs have essentially waited until their time ran out to come back and ask this court to rewrite the town charter, which was significantly, deliberately crafted to make the process of referendum or vote or veto difficult, but not impossible.
I'm at a real disadvantage here because the complaint was so sparse. I have absolutely no understanding of what went on. I didn't even know, because it wasn't in the complaint, that April 5th was the date. I take it there were a lot of events before April 5th that forewarned that April 5th would be the day when they request the funds. I assume that there was a town vote at some point down the line, and this has been going on for years. See, I have no understanding as to the history of this.
I'm happy to explain the process.
But I take it that there was a process, and April 5th was the final day for this. And the council had the ability to say, we don't want to go forward.
Yes.
Is that a fair statement?
Yes.
Okay.
Yes. And in addition, it's not only that there was time, it's not only that they knew, it's not only that the vote was coming, it was discussed about like that in all sorts of media. It was everywhere. And you know, just to say, the town is open, you know, providing services by appointment, and there have been 2 gatherings, large outside gatherings, during the time period that the plaintiffs were collecting signatures. Their failure to avail themselves of due diligence, to whether it was to get more people to help with the signature gathering or to have a better plan at the beginning, that failure is why they're at a disadvantage today. It is not because of COVID-19.
Okay.
Okay. Thank you, Your Honor.
Very brief.
Yes, very brief, Your Honor. Yes, thank you. The fundamental constitutional rights of voters are not contingent on grants. And granted, there is $35 million at issue here, but this is exactly what the public interest should be able to weigh in on by having a townwide referendum. Your Honor mentioned that you assume there was a townwide referendum on this issue. There has never been. And this is part of why the public is demanding this. 1,088 signatures in 2 weeks is a huge show of what the public interest is. They want to vote on this. But even the whole idea that because there's a grant that might be lost, somehow we give short shrift to constitutional rights. That is not what the Constitution is about. Fundamental rights must be respected regardless of grants. And that's what we have here. In terms of the dates, Your Honor, I just bring your attention to there was an amended complaint filed that's much more comprehensive. We filed a complaint quickly to get it to the court's attention.
I did review the amended complaint, and I couldn't figure out how we got to this point.
Yes,
I mean, they didn't even have the April 5th date in it.
The April,
I had to go back and look at some exhibits to kind of fish that out.
Yes, Your
The
Honor.
amended complaint was talking about how difficult it was to get signatures.
Right.
So I have no understanding of how long a process this was.
Right.
What you went through, what the town went through in this process. What this last meeting on April 5th was this something that was simply pro forma? Was there a legitimate, I have just no understanding of that. We're starting right at that point when you're trying to get signatures.
Yes, Your Honor.
And I do understand it was very difficult to get signatures during that time.
Yes, and we would say that, so April 5th was the vote of town council that we are then appealing with the petition. There's no way we could have triggered a petition sooner. It only can be triggered by that April 5th vote. And so, and I would say the fact that there were discussions for a period of years is really irrelevant. What we're here to talk about is, were the constitutional rights of voters and of petitioners violated? And so whether the project is a good one or not, whether it was discussed for X number of years is really not the issue. And it's really shouldn't weigh in to the calculation of whether the COVID-19 imposed a significant interference on petitioners' ability to collect signatures. And I think there are countless ways. I've referenced numerous ways in terms of going door to door. I would also point out that one of our petitioners who's here in the room, Pat Holland, who is a former president of the Jones Library Trustee Board, she is at a residential facility for elderly people and talked about how hard it is to collect signatures there. Frank Gaddy is also in the Arbors, which another residential home, and he points out that people are eating in their rooms. He can't collect signatures in the dining area because people, for the most part, are staying in their rooms. Even Ms. Holland talked about how they resumed some activities in her facility, such as movies, but people have to sit 8 feet apart. How can you petition someone if you're sitting 8 feet apart? All of these collective interferences, significant interferences, surely accounted for more than 22 signatures, probably accounted for hundreds. Giving an additional week is not only reasonable, I believe it's constitutionally required. In terms of there being other gatherings, they mentioned that there were 2 large gatherings. The town manager's affidavit references one in March. That was not during the time period of petitioning. There was another reference to a drop-in in a parking lot where over a period of a couple of hours, several people came. But that is nothing like having the regular town committee meetings in person. That would be where you'd find registered voters, and you might find 20 to 30 in one location. You can look up on the town website where the meetings are occurring, and you could go from meeting to meeting. None of that was possible because everything was online, and town hall isn't even open. So the real question here is not, is this a good project and how long have they been discussing it? It's, have the constitutional rights been significantly interfered with because of COVID-19? The defendant is saying no interference whatsoever and we have no obligation to do anything. But that's not what any other court has said. That's not what any state legislature has said. The entire country, the entire world has recognized COVID-19 as a crisis, as an emergency. And the fact that the town of Amherst gives nothing to accommodate this petition drive that we in earnest tried to do under their rules and discovered within a few days it is not possible to pretend that COVID-19 doesn't exist. And then there is a claim that we should have gone earlier. Well, would the answer from the town council have been different if we asked them on the second day, can we have more time and allow electronic signatures? No. The answer would have been exactly the same. No. And the answer would have been the same, no, we do not consider this an emergency and we will not even call a special town council meeting. The answer has always been from the town council and the town of Amherst that there will be zero accommodation. They pretend that COVID-19 as an emergency context for this petition drive does not exist. That violates the petitioners' and voters' fundamental rights. The voters have a right to vote on this. That applies strict scrutiny, and clearly there are reasonable alternatives. One additional week of canvassing would not have impinged on the rights of the defendant, and it was required constitutionally in order to have the constitutional rights for both petitioners and voters be preserved. We ask for that one additional week and the other remedies requested, but at least one additional week would be the bare minimum, and there's relatively no inconvenience to the defendant.
Okay, thank you.
And we would like additional submissions, so appreciate it.
It sounds like the parties want a decision by Friday.
Your Honor, the parties, the defendant could have given us those 200 pages of documents before last night. This delay is their own doing.
Well, I'm not going to blame them when it's the plaintiff who brings the emergency motion. In this time, you've put the defendants in a very difficult situation. So I'm not going to blame them for that.
Also, I'd also point out that the Board of Registrars, the town is refusing to set a hearing date on that. That should be happening now. We gave an appeal last Friday. They're not setting a hearing date. I don't know why, but that should have been set immediately, considering this is so time sensitive, and yet they're not setting the date. There's mixed messages going on here, and this is not what due process should require.
Okay.
Your Honor, if I may, just quickly,
Go ahead.
I just want to say I think we're being distracted from what we really are here today to talk about. We're here to talk about whether the Charter's provisions in 8.4 are constitutional on their face,
Right.
which we assert that they are, and then whether the plaintiff has made a showing under a heavy burden to show a substantial interference with constitutional rights, without even discussing whether that the term substantial burden means that they were not able to collect or that they were substantially not able to collect. We know that that is not true. By their very actions, they have made that argument moot.
And I do understand that.
Thank you, Your Honor.
As being the argument.
And the other thing, in terms of intent, Your Honor, I would just like to say that the town clerk, just like the Secretary of the Commonwealth, has no right to waive laws, and instead the town clerk has to follow the laws. If the plaintiffs wanted to rewrite the charter for this particular situation, they should have asked this court to intervene earlier. There is no authority at the town level to do any of the things that the plaintiff has asked for.
Okay. Let me take this under advisement then.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, by what date should we submit things?
I would get it in by tomorrow.
Tomorrow.
I don't know when I'll be issuing decision, and if I issue decision quickly, it's going to be a one-line decision to be followed up with a decision later. But I have to think through that first.
Thank you, Your Honor.
Thank you, Your Honor.
The recess all right, please. Thank you.